Hi, this is Mark Wahlstrom, the host at the Legal Broadcast Network. I'm here in Austin, Texas, the site of the NASTA meeting. That's the National Structured Settlement Trade Association meeting. And we're conducting a series of interviews, and we're here reporting on some of the exciting things that are going on. And joining us is one of our friends and somebody who has a channel here on the Legal Broadcast Network, Matt Bracy. Matt, how are you today?
Just fine, thanks, and welcome to Texas.
Well, yeah, it's good to be here. I've first time for me in Austin, a beautiful city and a beautiful place here at the Barton Creek Resort. One of the things that we're looking to do, Matt, and one of the issues that's always on the minds of people in the structured settlement industry is the whole function of how the factoring industry, the primary and the secondary markets relate. As we know, the structured settlement business is really the primary market. People put structures in place, both qualified and non-qualified. We've done a whole series of shows on both and how they work and what the function is of this market. And the secondary market, as most people are aware, maybe some people aren't, is the factoring industry, of which Settlement Capital, your firm, and the factoring channel, as we mentioned before, one of the channels here in the Legal Broadcast Network, is one of the primary firms in this particular area. Can you just take a minute, just kind of update us on what the relationships are at this point, how the state of the relationship, I should say, between the primary and secondary markets?
Sure, I'm glad to. It's interesting at this point. I've now been in this industry for about 9 years, and so I've seen it come through all kinds of turmoil and ups and downs in the relationship between the primary market and what we call the secondary or the liquidity market, now also known as the factoring market. Right now, I'd have to say that things are actually very good, as evidenced by, we have an annual trade group meeting, which our trade group is called NASP, N-A-S-P, National Association of Settlement Purchasers. And we meet once a year with a large conference. This year, we were honored to have Steve Harris of Drinker Biddle come and speak. And Steve, as you know, and his firm, Drinker Biddle, represent a lot of insurers on the other side, shall we say, of transactions with us. We were honored to have him come and speak. We were also honored by the presence of Randy Dyer from NSSTA. He was there with us. He did not speak, but he was there. Those kinds of things, and Pat Hindert, who's also has a long history with NASTA and also has been a broker and is active in the industry, was there as well. All of that is evidence of how our relationship has developed, and to have said that any of these people will be present at a NASP trade group meeting even 5 years ago would have been absurd. And so, to me, the dialogue is important, and understanding each other is important, and the way you get that ball rolling really is by interaction. Right. And the fact that they were willing to come and speak, I thought it really was great.
Well, it really kind of the analogy that I put it to is that over time, a lot of animosities, a lot of market differences do tend to settle themselves out, and people begin to look at the reasonable aspects of it. I mean, I'm going to be a featured speaker here at the NASTA conference today in Austin on marketing, and we're going to be doing interviews with famed trial lawyer Joseph Jamail, who is also speaking here. 5-10 years ago, the thought of plaintiff experts and plaintiff attorneys being part of a NASTA meeting, again, would have been almost laughable. And now, as our industry has matured, as your industry has matured, the ability, I think, to deal in a civil and professional fashion and to look at the businesses as separate and in many ways, but separate, but also unified in their desire to make sure that more structures are written, that structures are written properly, but that people who are in structures that do need to get out have a safe, orderly, and financially feasible means to get out of it. And that really kind of leads me to my next question here. It's been a little to-do on the internet between the different bloggers and different people in our industry on the topic or the issue of broker compensation when dealing with a factoring company. By that I mean someone in my position, a structured settlement broker or a structured settlement planner or advisor who is approached by somebody and says, I have a structure, I know you're an expert in structured settlements, I need to get some liquidity, I need to terminate this deal for whatever reason. And we rightfully, I think, go and try and find an expert. Your firm, Settlement Capital, there's others out there. I certainly endorse your firm and services for the work that we do. But when someone's approached on that, there is this issue of whether or not that broker should ethically receive compensation, or whether they should simply pass the person along to the factoring company and not worry about compensation for it. What's your position on it? You've been following this debate between the various parties and factions on this. What are your thoughts, man?
You know, whether or not the person receives compensation is sort of one part of the issue. Mm-hmm. The key part of the issue for me is really disclosure. I feel like brokers and others who are involved in the transaction, add value. And traditionally, when people add value to a transaction, especially professionals, they get compensated for it.
That's right.
You know, I'm an attorney, and that's my background, surely. Stockbrokers bring expertise to the transaction, and they get compensated for it. So the first place I start with this issue really is disclosure, full disclosure. I think it is dangerous. I think for an attorney it would most likely be unethical to receive compensation from someone who thinks that you are either representing them or advising them or elsewise without disclosing that. So that's where I start as a floor, is full disclosure. I think that's a smart way to go. It's the right way to go. Whether or not they should actually receive the compensation to start with, you know, lots of people participate in these transactions and get compensated. The attorney who brings the action in court to have the approval, to receive the approval, is compensated.
Right.
Our company obviously is compensated in the form of profits.
Sure.
Sometimes the person who is transferring the payments is represented by an independent counsel who gets compensated. Mm-hmm. All these compensations have to come from somewhere, and to be honest, they always come out of the pot. Right. Obviously, if none of these people were there, the pot would be smaller. Sometimes through the effort of these individuals, it allows a transaction to happen at all. For instance, if no attorney can go to court to bring the action, there can't be one, there can't be a transfer. So that facilitates the entire transaction. So it's reasonable to assume these people will get paid, and without them involved in the transaction, it won't happen. Yeah. Same with the broker. To the extent that a broker is acting as an advisor, to the extent that the broker is educated, which I hope they all are, on how factoring works, you know, what the myths are about factoring, what the truth is about factoring, and can add value, I have no issue with compensating that person. Recognizing, number one, as I said, they should be that compensation and that role should be fully disclosed.
Right.
And the second is that it should be moving the transaction forward. In other words, facilitating the transaction. Oftentimes, you know, perhaps, for instance, if they get into a competitive situation, they start to shop or encourage the client to shop for the best factoring transaction, which I encourage everyone to do, then they're adding value. And I have no issue with compensation for adding value.
Well, see, and we'll kind of wrap up on this thought. From my perspective, as you know, I'm also a registered representative. From a compliance standpoint, I've always felt, and my compliance officers agree, that if I receive compensation or were to take compensation, I would now have to disclose that as an outside business activity, and it would fall under the scrutiny of FINRA, something that it's really not worth it to me to be compensated. So, you know, I don't want to paint myself as a saint by saying I never take compensation, but as you know, I typically do not receive compensation. But I absolutely agree. I think the biggest thing is, and what rankles people, is that when people don't know who's being compensated, they don't know how much, and the client or the end user doesn't have any determination as to what is fair value for the services provided. So I think as we wrap this up, the discussion is healthy. There's people that's polarized on both ends. It'll probably be settled somewhere in the middle of disclosure. I think you know, FINRA and many of these things, you know, it's going to require it. And the marketplace will decide what is fair, what is reasonable, as long as everybody knows in the transaction who's being paid and what services they're being provided.
That's right.
Matt, I want to thank you for joining us here in Austin. It's always a pleasure. You know, you're a great friend and advocate of the Legal Broadcast Network, and a big part of what we're doing, the whole firm is. And the expertise that you bring on this issue, you know, we always talk, I complain about it, it's sort of the third rail of the direct settlement industry, that nobody wants to talk about factoring. And when they do, we tend to get these polarizing arguments. And really, you've always been sort of the voice of moderation. Your long experience in crafting legislation, working on these, and working it through, I think just has helped immeasurably to elevate the quality of the debate and quality of information. And we just appreciate you taking the time to come on down here to Austin today and,
Sure.
and join us and just spend a little bit of time with us.
My pleasure, and thanks for having me.
All right, this is Mark Wahlstrom. It's been a special interview here on the Legal Broadcast Network. Thank you for joining us, and please tune in to all of our other content here on the Legal Broadcast Network.